Hi, my name is Ayu Purnama. I'm a student from International University of Batam from Faculty of Law. Today, I'm going to present my final exam presentation. First, let us know what is private international law. Private international law, also known as conflict of law, refers to the general term for the rules governing the handling and adjustment of civil and commercial legal relation involving foreign citizen and legal person in a country or jurisdiction. This kind of relationship is generally caused by foreign trade and the interaction between native and foreigner. Next, what is the reason of private international law? Different countries and regions in the world have different legal system and they deal with the same social phenomenon like birth, marriage, death, divorce, bankruptcy, contract, and the others with different legal rules. When a case has foreign relate factor, the rule of private international law reflect their usefulness to ensure that the relevant rules of the domestic law system are most appropriately applied to the case will not conflict with the rules of the forum, and to help the court find the most suitable, the applicable law of the case. Okay, now is primary link point. Primary link point of association is factor or circumstance of a set of facts that give birth to or create an private international law relationship. Factors included in the primary link point are: first is nationality. Differences of citizenship among the parties who conduct a legal relationship will give rise to the private international issue. For example, an Indonesian citizen married to a Dutch citizen, or an Indonesian citizen conducting a trade transaction with a German citizen. Second, the flag of ships and aircraft. The flags of ship or aircraft refers to the place where a ship or aircraft is leased for nationality and establishes which law control the ship or aircraft. The nationality of the ship or aircraft is determined based on which country the ship or aircraft is leased in. For example, legal action that occur or carried out by people or individual on ship or aircraft, such as binding international business contracts, shipping goods through cargo, ship or aircraft, accident that cause loss. Third, the domicile. Domicile issue can also be an important factor in the emergence of private international law problem. For example, a British citizen domiciled in Greece conduct a marriage with a British citizen domiciled in France. The fourth, resident. The issue of a person's residence can also give rise to private international law problem. For example, two Malaysian citizens who are temporary in Indonesia hold a wedding in Indonesia. Fifth, place of legal entity. Legal entities are legal subjects, also have nationality and legal seats. Generally, the nationality of a legal entity is determined based on the place or country in which the establishment of the legal entity is leased. For example, PT Indo Kohindo, a joint venture between several Japanese and Indonesian entrepreneurs, the PT was established under Indonesian law and domicile in Jakarta. Thus, the legal status of the PT is an Indonesian legal entity. Another example, Hongming Co. Ltd., a joint venture company between Indonesian and Singaporean entrepreneur, established and domiciled in Singapore. Then the company concerned is incorporated in Singapore law. Similarly, company established by several Indonesian entrepreneurs established company in Hong Kong because they were established and operate in Hong Kong. They must be subject to Hong Kong law. 6. Choice of law. To explain what is meant by the choice of law can be presented as follows. Two Indonesian citizens in Jakarta held a transaction to buy and sell goods materials of a factory whose delivery take a long period of time and the goods are imported from the United Kingdom. In the sale and purchase contract, it is start that the sale and purchase agreement is governed by English law due to legal option by the parties who close the trade contract in different legal direction from the national, they will give birth to private international law relationship. Next is the secondary link point. Secondary link point of association are factors or set of facts that determine which law should be used or applicable in a private international law relationship. Include in the secondary linking point are first, lex situs or lex recite, which is the place locate object. Second, lex loci actus, which is a place of legal action. Third, lex loci celebration, which is a place of marriage held or inaugurated. Fourth, lex loci contractus, which is the place of signing contract. Fifth, lex loci solutionis, which is the place of implementation of the agreement. And the last one is lex loci delicti commissi, which is the place of occurrence of unlawful acts. Now, here I have a actual case. That the case is a case involving a couple of French citizenship, and their marriage was formalized in France. When the marriage took place in 1854, neither party made a marriage property agreement or contract. After the wedding, they moved to England. Her husband died in England by leaving the testament legally made in England. The content of the testament apparently ignored all rights of the wife over marital asset. The wife then filed a lawsuit against testament and demand her right for joint property. And the lawsuit was filed in a British court. Here we can classify first the cases by the nationality. The nationality of the couple is French, and they took the lex loci celebration or place of marriage held in France, and they domicile and in England, and they choose England for their forum, and the lex loci delicti commissi, which is the place do the legal action, do the unlawful acts is England, and they use the choice of law is England. And what is the solution of this case? We can find out the most characteristic connection is England. And the conclusion is this case was classified as inheritance of testament or contract of marriage because they didn't make a property division contract when they got married. British law stipulate that if the couple does not divide their property before marriage, it is equivalent to tacitly acquiescing the marriage as joint property. So this testament is not valid in French or British. So here is my presentation. I hope this video is helpful for you, and thank you for watching.